Hello friends, welcome to KRK-Law Knowledge channel. Friends, today we will see remaining part of Post of District Judge Judicial Preliminary Exam question paper of year 2019 with answers. So friends, watch our complete video, like it, share it, comment on it. Don't forget to subscribe our channel. So friends, we will see question number 51. In which of the following cases an evidence given by witness in a judicial proceeding is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the facts which it states? Answer is option number D, all of the above. Means option number A, where the witness is dead or cannot be found. Number B, where the witness is incapable of giving evidence or is kept out of the way by the adverse party. Option C, where presence of the witness cannot be obtained without an amount of delay or expense which under the circumstances of the case the court consider unreasonable. Question number 52. In absence of any order under Order 21, Rule 33 of the Code of Civil Procedure, the decree in which mode of enforcement is limited to attachment of property is dash. Answer is option number C, decree for restitution of conjugal rights. Question number 53. A and B executed a note where A agreed to reimburse B to the extent of rupees 1000 on occurrence of loss. It is dash. Answer is option number A, a contract of indemnity. Question number 54. Any court may alter or add to any charge at any time before the dash. Answer is option number D, judgment is pronounced. Question number 55. The property mentioned in section 14 of Hindu Succession Act 1956 include property acquired by a female Hindu dash. Answer is option number D, all of the above. Means option A, by inheritance or device. Number B, at a partition. Number C, in lieu of maintenance. Question number 56. What is meant by court of record under the Constitution of India? Answer is option number B, the court which has power to punish for its contempt. Question number 57. A person is said to cause an effect dash when he causes it by means whereby he intended to cause it, or by means which at the time or employing those means he knew or had reason to believe to be likely to cause it. Answer is option number D, voluntarily. Question number 58. With reference to section 36 of Indian Evidence Act, which of the following maps is not relevant? Answer is option number D, none of the above. Question number 59. A judgment debtor who was detained in civil prison for non-payment of decree date was released on the expiry of the period of detention ordered by the court. Answer is option number B, he is not discharged from the debt. Question number 60. A becomes surety to C for B's conduct as a manager in C's bank. Afterward, B and C contract without A's consent that B's salary shall be raised and that he shall become liable for 1/4 of the losses on overdraft. B allows a customer to overdraw and bank losses a sum of money. Answer is option number B, a stand discharge as surety. Question number 61. Under section 218(1) of the Code of Criminal Procedure. A magistrate may try together all or any number of charges framed against an accused on an application by the dash. Answer is option number B, accused. Question number 62. Section 34 of the Indian Penal Code dash. Answer is option number C. It is only a rule of evidence and does not create a substantive offence. Question number 63. In which of the following cases can evidence be given as to the general result of the documents by any person who has examined them and who is skilled in the examination of such documents? Answer is option number D. When the original consists of numerous account or other documents which cannot conveniently be examined in court and the fact to be proved is the general result of the whole collection. Question number 64. With reference to section 11 of the Code of Civil Procedure, the expression former suit shall denote a suit dash. Answer is option number B, which has been decided prior to the suit in question. Question number 65. In absence of any fraud or willful wrong for the act of sub-agent lawfully appointed dash. Answer is option number C. The agent is responsible to the principal. Question number 66. In view of section 228 of Code of Criminal Procedure, the sessions judge is of opinion that there is ground for presuming that the accused has committed an offence which is not exclusively triable by the court of session. He may by order transfer the case for trial to the Chief Judicial Magistrate or any other judicial magistrate of the first class dash. Answer is option number A, after framing a charge. Question number 67. If the offence is punishable with fine only, what is the maximum period of imprisonment that can be awarded for non-payment of fine when the amount of fine does not exceed 100 rupees? Answer is option number C, 4 months. Question number 68. If a contract is contained in several letters dash. Answer is option number A. All the letters in which it is contained must be proved. Question number 69. If the original suit is dismissed dash. Answer is option number C. Counterclaim may be proceeded with. Question number 70. B. The proprietor of a newspaper publishes at A's request a libel upon C in the paper and A agrees to indemnify B against the consequences of the publication and all costs and damages of any action in respect thereof. B is sued by C and has to pay damages and also incurs expenses. Decide in the light of section 224 of the Indian Contract Act 1872. Answer is option number C. A is not liable to B upon the indemnity. Question number 71. To discharge an accused under section 245 of the Code of Criminal Procedure, the magistrate has to consider dash. Answer is option number C. Whether any case against the accused is made out which, if unrebuted, would warrant his conviction or not. Question number 72. Under section 72 of the Indian Penal Code, in all cases in which judgment is given that a person is guilty of one of several offences specified in the judgment, but that it is doubtful of which of these offences he is guilty, the offender dash. Answer is option number B. Shall be punished for the offence for which the lowest punishment is provided if the same punishment is not provided for all offences. Question number 73. What is the sentence which can be imposed by a court while allowing an application for plea bargaining in case where a minimum sentence is prescribed for the offence in the statute? Answer is option number B. Half of such minimum sentence prescribed in the statute. Question number 74. Section 76 of the Indian Penal Code is based on the common law maxim dash. Answer is option number A. Ignorantia facit dot excusat, ignorantia juris non excusat. Question number 75. In the case of plea bargaining, a statutory appeal may lie from the judgment passed under section 265G of the Code of Criminal Procedure to the dash. Answer is option number D. No appeal lies against the judgment. Question number 76. X, a snake charmer claiming magical powers of curing snake bites, asks why to be bitten by his cobra. Why an adult, under misconception that X has such magical powers, offered himself for snake bite and died. Here, answer is option number A. X cannot claim consent as good defense under general exception. Question number 77. Who among the following may be examined as witness by issuing a commission as per the proviso to section 284 of the Code of Criminal Procedure? Answer is option number D. All of the above, means option A. President of India, option B. Vice President of India, option C. Governor of State. Question number 78. Which of the following statement is true? Answer is option number C. Both A and B. Number A. A person is not deprived of the right of private defense against an act done or attempted to be done by a public servant as such unless he knows or has reason to believe that the person doing the act is such public servant. Number B. A person is not deprived of the right of private defense against an act done or attempted to be done by the direction of a public servant unless he knows or has the reason to believe that the person doing the act is acting by such direction or unless such person state the authority under which he acts, or if he has authority in writing unless he produces such authority if demanded. Question number 79. The doctrine of autor fois acquit and autor fois convict is incorporated in section dash of the Code of Criminal Procedure. Answer is option number C. 300 section. Question number 80. A instigate B to murder D. B in pursuance of the instigation stabs D. D recovers from the wound. Answer is option number A. A is guilty of instigating B to commit murder. Question number 81. Which of the following is not an acquittal for the purposes of section 300 of the Code of Criminal Procedure? Answer is option number C. Both A and B, means number A. Dismissal of a complaint, number B. Discharge of the accused. Question number 82. A with the guilty intention abets a child to commit an act which would be an offence if committed by a person capable by law of committing an offence and having the same intention as A. Here, dash. Answer is option number A. A is guilty of abetting an offence. Question number 83. If the forgery was committed in respect of document produced in any court, then prosecution can be launched only with a complaint made by the dash. Answer is option number A. Court. Question number 84. A intentionally gives Z a shortcut or club wound sufficient to cause the death of a man in the ordinary course of nature. Z dies in consequence. A may not have intended to cause Z death. Here A is guilty of dash. Answer is option number A, murder. Question number 85. A magistrate to whom a complaint is made under section 340 or section 341 of the Code of Criminal Procedure shall proceed as far as may be to deal with the case as if it were instituted dash. Answer is option number A, on a police report. Question number 86. A without any excuse fires a loaded cannon into a crowd of persons and kills one of them. He may not have had a premeditated design to kill any particular individual. A is guilty of dash. Answer is option number A, murder. Question number 87. With reference to Information Technology Act 2000, data record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche means dash. Answer is option number A, electronic record. Question number 88. Intending to murder Z by poison purchases poison and mixes the same with food and places the food on Z's table. Answer is option number A. A has committed an offense of attempt to murder. Question number 89. The victim shall have a right to prefer and appeal against any order passed by the court dash. Answer is option number D, all of the above. Means number A, acquitting the accused, number B, convicting for a lesser offense, number C, imposing inadequate compensation. Question number 90. A meets a bullock carrying a box of treasure. He drives the bullock in a certain direction in order that he may dishonestly take the treasure, and bullock starts following A. Answer is option number A. A has committed theft. Question number 91. Where a high court passes one year sentence of imprisonment for a term not exceeding dash, no appeal will lie against it. Answer is option number B, 6 months. Question number 92. A is the paramour of Z's wife. She gives a valuable property which A knows to belong to her husband Z and to be such property as she has no authority from Z to give. A takes the property dishonestly. Answer is option number A. A has committed theft. Question number 93. In an appeal from a conviction, the appellate court can dash. Answer is option number A, 1 and 2 only. Means number 1, reverse the finding and sentence and acquit the accused. Number 2, alter the finding maintaining the sentence. Question number 94. A holds Z down and fraudulently takes Z's money and dwells from Z's cloth without Z's consent, and in order to the committing of the theft, he has voluntarily caused wrongful restraint to Z. A has therefore committed the offence of dash. Answer is option number A, robbery. Question number 95. Which of the following irregularities done by a magistrate not empowered by law to do those things vitiate proceeding? Answer is option number C, attach and sell property under section 83 of the CRPC. Question number 96. A finds a check payable to bearer. He can form no conjecture as to the person who has lost the check, but the name of the person who has drawn the check appears. He knows that this person can direct him to the person in whose favor the check was drawn. He appropriates the check without attempting to discover the owner. A has committed the offense of dash. Answer is option number C. Dishonor, misappropriation of property. Question number 97. By which of the following judgment the Honorable Supreme Court extended the benefit of Article 21 of the Constitution of India to ensure just, fair and reasonableness in the procedure established by law? Answer is option number B. Maneka Gandhi case. Question number 98. Doctrine of holding out with reference to Transfer of Property Act is related to dash. Answer is option number A. Transfer by ostensible owner. Question number 99. A commits house trespass by entering Z's house through the door, having lifted a latch by putting a wire through a hole in the door. This is dash. Answer is option number A. House breaking. Question number 100. Section 52 of Transfer of Property Act is based on the principle embodied in the maxim dash. Answer is option number A. Ut lit pendent nihil innovator. Thank you friends.